Good afternoon and welcome to the BRR Legal Brief, looking at the major legal issues affecting corporate Australia. I'm David Bushby and I'd firstly like to welcome to all our viewers watching via mobile phone. Today is the first time we're broadcasting to iPads and Android phones and whatnot, so welcome to the small screen if you're tuning in via that method. Talking tech today and sticking with tech, we're talking about Twitter and the defamation case or pending potential defamation case against the social network giant. And here to discuss what this means for online publishers and social media is Miriam Steele from Allen's Arthur Robinson here in Sydney. Welcome, Miriam.
Thanks, David.
Miriam, just to kick us off with this case, what happened here?
Okay, well, it started with a tweet. Marika Hardy, the author, posted a tweet in which she referred to her anonymous internet bully. She didn't name that person, but her tweet also included a link to her blog in which that person was named as a Melbourne man by the name of Joshua Meggett. Turned out Meggett wasn't the person in question, and there were reports that initially he sued Hardy for the defamation. That case is reported to have settled for about $15,000, but it looks like he's now turning to Twitter as the publisher of the platform on which the tweet was posted, and is now claiming, it's now reported that he's suing them for defamation as well.
Well, obviously Twitter's been around for quite a while, and I'm sure plenty of defamatory tweets have been tweeted and retweeted around the world. So why has it taken this long for this sort of action to occur here? Okay,
well, as you say, Twitter has been around a long time and is very widely used. So there have been a number of defamation cases brought around the world involving comments posted on Twitter. Courtney Love has been sued twice in the US for things that she posted, and there have been an increasing number of cases in the UK. But up until now, the cases have been brought against the person who has actually done the tweet. This appears to be the first time, certainly in Australia, that Twitter itself as the platform has been sued, and I guess probably it was really only a matter of time that that would happen, although it's interesting that it has happened in Australia and not the US, because the US has specific legislation which protects an online provider of content where they are merely publishing content by third parties. So it's unlikely that an action like this could be brought in the US.
Well, I guess keeping with that theme and going into a bit more detail, what will be the issues, do you think, in this case?
Okay, well, I think for Australian defamation law, it's quite broad in terms of who can be liable for defamation, and anyone in the chain of publication can be held responsible. Now, in the context of social media, where comments and material can be so broadly and quickly disseminated, that has really significant implications, obviously in this case in the context of the platform itself, but also looking at Marika Hardy. She has 60,000 followers on Twitter, and her comment was retweeted and a number of users commented on it, so potentially each of those people could also be liable. And there's also a possibility that Twitter, because of its terms of use with the users of Twitter who are held responsible for the content that they tweet, potentially Twitter could bring actions against each of them or cross-claim if it's found liable.
Well, it would be an absolute can of worms.
Absolutely, it's a minefield.
Just on the, with Twitter, it's obviously a US company, as are most of the major social networks globally. So how can, I guess, a US company then be brought or be found liable here in Australia? Okay,
in defamation, it's where the damage to the person's reputation occurs that's relevant. And this issue in the context of online publication was considered about 10 years ago by the High Court in a case brought against the US publisher Dow Jones, and the High Court in that case confirmed that where materials are published by on an overseas service but available and received by Australian users, the action can be brought here.
Well, finally, lessons for online publishers and social networks. What are we looking at? Okay,
well, I guess it's important to recognise that under Australian defamation law, there is a defence to defamation if you can prove that you didn't know or ought reasonably not to have known that the material in question was defamatory. So for social media organisations and online publishers, I think They need to be really careful about the extent to which they add any editorial comment or moderate the comments that are published by users if they want to be able to rely on that defence. And I also think it's important for them to have policies in place where they can quickly respond to any allegations about defamation content and pull that down so they can't be seen to be liable in that context as well.
Awesome, great lessons for online publishers, and we'll certainly keep a very close eye on this Twitter case as it proceeds through the various hoops to court eventually, I think. But thank you again for your time today, Miriam.
It was my pleasure.
And thank you, viewers, for tuning in. We look forward to having you next week, hopefully on the small screen as well, for the BRR Legal Brief.